Hi folks, it's me, Suze Pratt, the Holistic Stylist, coming to you with a great episode of Book Club this evening. Tonight's ancient read is called Cosmetology Jurisprudence. This book was published in 1938 and contains all the major lawsuits brought against hairdressers from 1880 to 1930. Even better, and why this book means so much to me. My beauty school teacher, Sheila, who I'm still friends with to this day, was who gifted me this book, and it became part of an extensive collection of the history of hairdressing, which now I'm excited to say will become part of a online cosmetology museum. So it's pretty exciting. But this book is also very important today, which is why we're discussing it on Book Club this evening. What I find particularly enlightening is why our industry has been considered undesirable or dangerous. In many towns, local ordinances and regulations kept many artisans from earning an honest living. Back in the day, it was the barbers themselves, in order to limit the number of their calling or to invade the beauty industry. Today, the distinction is a clear line in the sand. Cosmetologists engaged in hairdressing do not learn how to work with a straight razor in beauty school. Barbers do learn how to mix, measure, and apply chemicals to members of the opposite sex in this day and age. Now, in our small town of Ferguson, believe it or not, I've been told that the local ordinances and regulations supersede what the state has to say and supersede, of course, cosmetology jurisprudence. So this is personal to me, and I'm a self-educated person. So I thought it'd be interesting to share this information and see what other professionals and non-professionals thought. I'd like to start out on page 199 in the back of the book. Before that page, pretty much it's all the lawsuits that were brought against the cosmetologists and the barbers, especially when it concerned the chemicals or the services being performed. Okay. This lawmaking epidemic has extended to many cities, and all sorts of ordinances, good and bad, frequently foolish and ridiculous, have been adopted to the great discomfort lost my place, sorry about that. Great discomfort of the tonsorial fraternity. What the actual motives behind all this legislation were, it is difficult to state. Whether it was designed to get additional revenue under the guise of protecting the public health and morals to create some more political censures, or whether it has in some instances been instigated by certain groups. Okay. Page 207, I'm going to. They contend that, as to them, the law is arbitrary, unreasonable, oppressive, and deprives them of the protection afforded by the 14th Amendment to the Constitution of the United States, which declares that no state shall deprive any person of life, liberty, or property without due process of law. It goes on to say, but the term is defined to embrace the right of the citizen to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his living by any lawful calling, to pursue any livelihood or avocation. The legislature may not, under the guise of protecting the public interest, arbitrarily interfere with private business or impose undue and unnecessary restrictions upon lawful obligations. Next, page 251. I love my book collection. I have so many rare and collectible books. Also a lot of modern day stuff, and I like to tie the synchronicities together. It shows a continuation. Now these are your rights under the Constitution, and what we're talking about here is the idea that property, now we're talking about the definition of property, within the meaning of that guarantee includes the right to engage in those common occupations or callings which involve no threat to the public welfare, to exercise a choice in the selection of an occupation, and to pursue that occupation in his own way so long as he does not interfere with the rights of others. No man's liberty is safe if the legislature can deny him the right to engage in a harmless calling. And as a holistic stylist, I have been engaged in first doing no harm since 2005. And it goes back way farther than that. But on paper, and as far as what my business mission statement is, so we're going almost 11 years now. The right to follow any of the common occupations of life, of the ordinary callings, is one of the privileges of a citizen of the United States. That's interesting. Okay. Now in my case, like I said, I've done no harm. And of course, this is in every aspect of cosmetology. I am a specialist in areas that I choose to work in, so I don't engage in the harmful chemicals that brought so many lawsuits to these poor hairdressers and barbers who weren't educated on what the chemicals do. They were educated on how to mix, measure, and apply. And because we have a license, when we purchase the chemical, all liability transfers to the hairdresser and away from the manufacturer that creates this hodgepodge of chemicals. And the FDA says that y'all enjoy them so much that it's not much of a big deal and they can't deny you of these pleasures. But these days, really, we're just looking at how to do things in a safer manner than what was done in the past before there was disclosure. Okay. Did you know that hairdressing is listed in the top 5 most toxic service industries? And that's a lot to be said. So, where I live in this town, I'm undesirable. And in 2008, beauty salons were reclassified as restricted, where I came to live in 2007 and planned to work. At the time I was in Florissant. Have the limits been passed as far as intentional trespass? That's something that we're going to explore. And so now we're back to our book, page 208. You can see I take my career seriously. You know, there's great responsibility in freedom. And of course, back in the day, it was overlooked or called a mistake. But these days, we're beyond that, aren't we? Okay. It's hard to see my yellow highlighter in this room. Now what we're doing is we're talking about our system is supposed to work for us. So, it says, it does not follow that every statute enacted for the protection of the ends is to be accepted as the legitimate execution of the police powers of the state. There are of necessary limits beyond which legislation cannot rightfully go. The courts must obey the Constitution rather than the lawmaking department of government, and must, upon their responsibility, determine whether, in any particular case, these limits have been passed. The court are not bound by mere forms, nor are they to be misled by mere pretenses. They are at liberty indeed, and are under a solemn duty to look at the substance of things, like the story, whenever they enter upon the inquiry whether the legislature has transcended the limits of its authority. If therefore a statute purporting to have been enacted to protect the public health, morals, or the safety has no real substantial relation to those objects, or is palpable invasion of the rights secured by the fundamental law, it is the duty of the courts to so adjudge, and thereby give effect to the Constitution. As we're deemed manual labor because we work with our hands, and that, believe it or not now, they're saying that that may not require mental sharpness, and only things that are professional are mental and require that sharpness. Well, now, that's an oxymoron if we're going to sue people for being ignorant to the facts that were kept hidden, isn't it? And of course now we see that, but here we are in this day, and it runs rampant again. Okay. I hope to bridge the gap as a nationally accredited, board-certified hair colorist in a world where I've been targeted, slandered, and stripped of my 14th Amendment rights, so it seems, for dubious reasons, which I have detailed to my State Board of Cosmetology, with the hope of creating a future full of hope and promise, and of God-given, inalienable rights as provided in the Constitution. Back to our book. My favorite drink is tea. I don't know about you guys during book club. I have my green tea on the floor. Okay. So, here we go. And the guarantee of due process has often been held, demands only that the law shall not be unreasonable, arbitrary, or capricious, and that the means selected shall have a real and substantial relation to the object sought to be attained. In order to provide an extraordinary and harmless calling, I opened a salon by the age of 21. The reason is so I could choose safe alternatives to the status quo of the average. And in this book, it says we are being upheld to be average. And so, when I came to this town, I was approved under Article 15.9 Special Provisions Clause. I have proved myself unique and well qualified to run a successful program. Now, this flow chart that I made up here and submitted is the most, well, I don't know if you can see it from here, but they consider where I live to be one of the most dangerous cities in America. And we're a small town of 22,000. Now, Missouri is historically known for being a divided state, and 10 minutes away from where I live, at the time of the writing of this book, slavery was legal, and right on the other side of the street, people were considered to be free. So, I think we have a karma that we're working through as far as that goes, and not just here in Missouri, guys, but everywhere. And now we're understanding how laws are written and interpreted. You know, one thing I wonder is, are we the forgotten? I mean, is it just about black and white to some people? Because I don't consent to that idea. I feel that no matter where you live, or no matter what your socioeconomic status is, that you should be able to be the best you can be and be okay with it and love yourself. And so this is very difficult, I'm sure you can imagine, because our profession is so closely linked to human relationship and to all the things that makes a career worthwhile. Now, since I was wrongfully and illegally evicted out of the building where the walls were that contained my DBA, which is Hair Emporium, I am Suze Pratt, the holistic stylist, always doing business as the Hair Emporium, and no one can take that away from me. So this is the beginning of the online arm of how I serve friends as a spiritual human being, a holistic stylist. So we're jumping way modern, aren't we? But we're going to jump back to the book and connect. Go into page 220. There's a story here. This is under ordinances regulating beauty shops. But it goes on in this thing where the Supreme Court reversed this woman's case, that she had been brought up on. And we're talking about in Wilkie versus Chicago. This court held that while the legislature may delegate power to a municipality to grant a license for a particular occupation and exact a license fee therefor, it may at any time take away such power and may resume the exercise of the power. That a city, as a subordinate political authority, cannot interfere with the validity or force of the license issued by the state under a statute. The statute controls the whole subject matter. The statute repealed any power to the city and had to regulate and license beauty culture, quoting from an Illinois case. Like I was saying, to take something like a hair salon and suggest that it should be a restricted use, that suggests that there is a preconceived, negative, prejudice, kind of a something working behind the scenes. We'll just say it like that. Now, all I'm asking for is a chance that I was already granted. And we'll go into this on my YouTube channel, Suze Pratt. We're also getting ready to launch Hair Emporium Unplugged, which is where we'll really define how I can help you, even if you don't live by me or you don't know me. And that's really what it's all about. In closing, book club this evening and talking about professionalism. Oh, that's right, we can't be professional. Okay. Sounds fishy to me. 251. Back to property. Believe it or not, we kind of are so materialistic these days. We think that means our house or something. And that's just so far from what they were referring to back then. Alright, so let's pick up and start reading. They constitute an arbitrary prohibition rather than a reasonable approach to a lawful and chosen work. These restrictive measures strike at the foundation of the trade in that they wrongfully and illegally interfere with those who wish to engage in it, and if strictly enforced, few would be able to accept this calling and engage in its activities. This constitutes an unreasonable and illegal exercise of police power. No man's liberty is safe if the legislature can deny him the right to engage in a harmless calling. The right to follow any of the common occupations of life is an inalienable right. We read this before, but it's just good to hear again, isn't it? The right to follow any of the ordinary callings of life is one of the privileges of a citizen of the United States. Property, within the meaning of that guarantee, includes the right to engage in those common occupations or callings which involve no threat to the public welfare, to exercise a choice in the selection of an occupation, and to pursue that occupation in his own way, so long as he does not interfere with the rights of others. So, first do no harm, guys. And in my line of work, sometimes they say, the customer is always right. And I have a picture that I took in Chicago at a diner, and it said, the customer is usually right. So, considering that I am self-educated, I'm going to say to the powers that be, sometimes you guys are right, but there are exceptions to the rule. Let's put down the petty differences that divide. Let's leave greed out of it. And let's help every community to learn to love, to read again, so they understand and understand who they are. With that, peace, love, and light from the third cosmic ray. I hope you enjoyed Book Club tonight, and I look forward to your comments. Thank you.